My name is Heather Shore. I'm an attorney, Brown & Craig Law Firm in Kansas City, Missouri. And my primary focus is construction, litigation. I also do surety law, and I represent contractors, subcontractors, owners. I've handled arbitrations against Walton, no offense to the ex-Walton employees. I handled all the litigation involving Fort Riley. There was a $93 million lawsuit involving Fort Riley on behalf of Alpha Baby. So I've been, I've handled $1,000 liens and $93 million lawsuits. So I have an extensive amount of experience. No case is too small or large. What I'm going to talk about, the reason I chose the topic of contracts is because to me, this is where all the litigation arises out of. And what I think is really unique about your profession is that you all are really hired to build buildings or design buildings or to develop and basically you're in the construction industry. But I don't think you guys realize how important it is for you to understand contracts. I really honestly don't know of another area of business other than lawyers or people that are just hired just to review contracts every day. There's not really another area of business where you are essentially forced into the role of kind of a lawyer or a person that has to review contracts. You have to understand legal issues. And I don't know that y'all have ever stopped to think about that, but you have to understand the terms of the contract, the legalities, and how all of that impacts you. And so, let me ask you this, are most of you in the room estimators? Okay, so really it starts with you. I know I have some owners in the room, contractors, subcontractors, what about owners, developers, and then engineers, architects? I don't really care about y'all. No, I'm just kidding. We have one. Okay, so when you're estimating a job, why does it matter what the contract says? Well, if you're estimating a job, it starts with you. You can be the best damage control for your business because you have to understand what the scope of work is, right? You have to understand what is the price you're getting paid. And then you have to understand things like timing mechanisms, timing of payment, what's the expectation on the schedule, and those sorts of things. And by the way I do this is, I'm not going to stand up here and talk for the next hour, okay? That's just not how we're going to operate. You guys are going to, this is very interactive. This is how we all learn. I want you to throw out ideas. If you disagree with something I'm saying, I want you to challenge me, because that's really how we're all going to learn. We're here kind of as a round table to toss out ideas. I'll talk to you about the basic principles, but I want you all to think about what are some real life experiences and let's share them with each other so we can have some camaraderie and exchange those ideas and experiences. But essentially, what I want you to remember as a estimator is you really have to think about the risk that your company or that you are taking on before you enter into the contract. And it's not just, it's really, guys, it's not just about a house. It's not just about checking the box with the scope of work and everything else. It's really thinking about who is the contractor that I'm about to enter into a contract with, what is their reputation in the community, are they reasonable at the end of the day, will they try to, get me to demolish work and not approve my change orders, am I in Kansas, am I in Missouri, am I in Colorado, am I in Oklahoma? All of those things matter because, for example, when you're in Kansas, and you have a change order, and somebody comes to you and says, I want you to do this extra work, you better get the change order in writing, because if you don't, you're probably not going to get paid. Okay? Kansas is very strict on that. They want you to have everything in writing. They don't want any ambiguities in the contract. Missouri, a lot more laid back. You're out on the job site, you have a mutual meeting of the minds, I want you to add more CMU here, do whatever. As long as you can testify about what it is you were asked to do, and the other side, there's some evidence of that the other side instructed you to do that, or there was an agreement about how much you're going to get paid, then Missouri courts are more likely to allow there to be a modification of the contract verbally or orally. So those are the things as estimators you really need to be thinking about. In this handout that I gave you, it's very detailed. I go into a lot of detail about the things that you ought to consider. We'll touch on each of them. But obviously the scope of work is one of the more significant areas. I've litigated cases where the scope of work lists all the things that the subcontractor is going to do, and then under exclusions, it lists some of the same things the contractor said they would do. And so parties get into these really expensive lawsuits about what is my scope of work. And so if you're the estimator, you need to be very meticulous and methodical and think about, is staff lien included, is it not included? You know, is this area of work included or not included? I think that focusing on your exclusions can be just as important as focusing on what you are doing, depending on the type of the job. So I really encourage you, as you're developing the scope of work, estimating the scope of work, to be thinking about inclusions and exclusions. The other thing that I see a lot, which I don't understand, is a lot of us, Rob's in the room, Rob Picken, he's a construction lawyer, and a lot of times what we're litigating about is what was the scope of the work. And it's amazing to me that subcontractors will say, well, the plans were horrible, and you know, I just really didn't know, and they didn't really tell me. And there's this concept in the law that if it can be reasonably ascertained from the contract documents, you have a duty to include it in your bid. Well, what does that mean? That means if you walked into this room, or if you saw plans on a piece of paper for this room, and you didn't see any lights indicated on the plans, someone would say you should reasonably have assumed there would be some lights in this room. Now, not as many can lights and things like that. So one of the things that I try to encourage my clients to do is, if the plans are not specific, or if you don't understand that, or if they're in conflict during the course of estimating, then do an RFI. There's nothing wrong with doing a pre-construction RFI. I mean, do any of y'all do that? And it doesn't have to be in the form of an RFI. Now, let me tell you something. That becomes part of the contract documents. So don't do it verbally. It should be in writing. It's just as important as the RFI that you issued during construction. Because if you had some question about it, inevitably somebody else had a question about it, and either it should get changed, you know, through the architect supplementation and ASI or something like that, or it should be, you know, placed on the plans during the course of the process of bidding, and then when you get to 100%. But in the unlikely event that it's not, at least you have a written bid process RFI where you can come back and say, no. I asked you about how many lights you want in here, and you only said 10, so I bid 10. If you want 20, you're going to have to pay for the other 10. So I don't know how many of y'all do that. A lot of people are like, well, you know, I felt like if I did that, then, you know, nobody else would ask a question, and the bids wouldn't be even, and mine would be more. And I just say hogwash, because it's more expensive down the road to be litigating about it. And trust me, I mean, I love what I do, but you do not need to be spending a bunch of money with lawyers litigating over what your freaking scope of work was. It's just a waste of money. Yeah.
So as a subcontractor, I have to build the way it's engineered and drawn. If I know it's wrong, I still can't change it. So if I bid a job for what it is, not having the power to change it, I'm not an engineer and I didn't design it. And I notify them that they have a problem. How can I do the same thing on the job?
Well, that's kind of a different issue in my mind. So what I think you're saying is, if I build it to plans, then aren't I off the hook? There's a case out there. There's a United States Supreme Court decision called the Spirit Doctrine. Okay, and it's been adopted. There's a really good case out of Missouri. It's like, I think, 2 or 3 years old, and Rob may know the name. I don't remember the name of it. It's an excellent case, but in that case, they did a very thorough analysis of the Spirit Doctrine, and they re-adopted it in Missouri. It's kind of lost favor in a lot of states, but essentially the concept is, if you build a project per the plans, and you follow the plans exactly as they are laid out, then you should be paid, and the owner has essentially guaranteed that you will be paid, because if it's wrong, it's wrong. There is a body of law that supports that, okay? but you have to let common sense prevail.
I mean, I'm not gonna build it. I'm so maybe I win the job. I know I have a problem. I get contracted. I send an email. I say, hey, I think you got a code problem here. Or I think we have an issue.
Okay.
So I identify it.
So you raise your
I already won
hand.
the job. Yeah, I've already won the job. At this point, I didn't give anybody else a better advantage and tell them that something's wrong.
So your question is, if I'm out on the
If I've
job,
got a job and then I found a problem, I might have won it when I did it.
well, the answer is, there's two answers to that. One is yes, you always want to raise
Yeah.
your hand and point out the problem, document it. And if they tell you to proceed and it's contrary to code, document it again. If they tell you to proceed, then you do it, and you've got probably a very good case. However, I will tell you that in most contracts in this day and age, there's a duty for you to go out before you sign the contract to walk the job, inspect the job, make sure you understand the conditions, to review the plans, to make sure, because the first question I always ask people, I have a case right now where I'm litigating the hell out of the question, and is, what's different today than when you bid the job 3 months ago? I mean, how did you have this revelation now that there's this issue with the plans when nothing has changed? And you should hear some of the bull crap that I'm getting, but that's what you have to ask yourself. But I think you're right.
That's personal ethics. And that we can teach all of it.
That's right, and I've taught that class to you guys in the past,
Yeah.
and there's like 3 cases in the US on that, and that's it, and you're right, it is an ethical issue. But I think that that's a very good practice. Raise your hand, when you're an estimator, I know this is not reality because you guys are really, really busy, you're under a lot of pressure, you've got to get these bids in very quickly, you're doing the best that you can. I mean, I appreciate that sometimes what we tell you all is not reality, but I'm telling you from a perspective of what a judge would tell you, and judges, for the most part, and this is, there's a lot of really good judges, and I'm not trying to be disrespectful, but most of them do not come from a construction background. Okay? They come from a contracts background, or an insurance background, or think about the jurors that might be deciding your case. These are not people that are trained in reviewing plans, reviewing specifications. You're either going to draw from somebody's life experiences, usually is not construction, or you're going to draw from a judge who was a lawyer at one point in time that was likely in criminal law or something. So you've got to get that contractor hat off when you're reviewing the contract and think about, in every case that I get in my door, I always think about, at the end of the day, what could be the potential outcome and what are the different road blocks to getting there. And I think when you're estimating a job, you really have to think about that. I've got this no damages for delay clause. How is that going to affect you? What if something happens and we get delayed? I'm working with this contractor who has a reputation for mismanaging projects, not properly sequencing the work, telling me I have to accelerate at my own cost. I'm probably going to have delays on this job, and I'm not going to get damages for that. All I'm going to get is time at best. How is that going to impact my company? How financially, what kind of impact is that going to have on us? Can you work that into the number? There's like an asshole factor sometimes that you just have to consider, And I don't mean to offend anybody with my language, but I think that we can all say, if we've worked in this business long enough, maybe it's the no jerk rule. I probably need to be more. Well, no, Trump is president. I can say whatever I want. Just kidding. But so, we just have to think about the jerk factor for a minute, or maybe you just decide you don't work for them anymore. The other thing I tell clients, and don't cringe when I tell you this, because I do think this is a really good business practice. You need a lawyer just like you need a good insurance person, just like you need a good banker. And I think in every bid that you do, you should factor in some amount for fees so that you feel comfortable that if a dispute arises, you can pick up the phone and call your lawyer, and you're not ever like thinking, oh my God, this is costing me, $300 an hour, because it might be the best $300 you've ever spent. The other thing is you should have somebody review your contracts so that you can help avoid these issues. But when you're estimating, think about the no damages for delay clauses. You also want to think about paid and paid. I know everybody, we represent a lot of contractors in town. down and all the subs call up and they don't want the paid clause. And most contractors are just not gonna strike that. So you're just gonna have to kind of learn to live with that ugly fact and figure that into, again, am I working with a contractor that I trust? Is there a bond on the job? Kansas or Missouri? Kansas law says if there's a bond on the job, if there's a paid clause, the surety can probably rely on that paid clause. So that's something to think about. That's counterintuitive. I don't agree with that decision. That's Judge Berger. It's out of a Corbin Park case that Rob and I were on for years. But so there's some goofy law out there that might ultimately prohibit you from getting paid if the contractor doesn't get paid. There's always an element of good faith and fair dealing in every contract. So back to your point about ethics. People do have to deal with each other in good faith. That's just the law in every state. Okay, that's applied in every contract, which means if you have a pay clause and the contractor is the one that's caused this situation where you're not getting paid, chances are you might be able to overcome that pay clause if you have a good lawyer, but I wouldn't count on it. Okay?
So,
Yeah.
You said that a few sentences back, had a bond on the job. I don't know if you're for corporate park.
Yeah.
If there was a bond on the job, was it the GC's bond or was it the bond like the
GC's bond.
it's the GC's bond?
Uh-huh.
They had a pay clause.
Right.
So why didn't the bonding company roll over and say, hey, you signed this contract, you weren't going to get paid?
I don't remember if it was the GC's bond or the subs bond, but essentially what happened was the party that gave the bond did not get paid. And so the surety said, well, if the contract, the bond incorporates the contract documents. So the paid clause is essentially incorporated into the bond. So now the surety says, hey, that clause, that paid clause is in the contract, and I don't have to pay because they haven't gotten paid. So Judge Berger, I think it was Judge Berger, rendered a decision which said the surety in that instance could rely on the paid clause, and a lot of parties did not get paid. And
That was in Missouri.
What's that?
That was in Missouri.
That was in Kansas.
That was in Kansas.
Uh-huh. And that's, you know, he's out of the bankruptcy court, and he was trying to interpret Kansas law. And I personally think that the decision is wrong because the whole point of a bond is to guarantee payment. But I do understand the logic behind it. It's similar to the arbitration arguments that a lot of sureties make where they say, we don't have to go to arbitration. And there's arguments on both sides of it, which is, well, no, you've bonded the contract, which requires arbitration. And so any dispute arising out of the contract has to be arbitrated. And Diane Lewis of my firm litigated this issue recently to the Kansas Supreme Court. And we actually represented the surety and we were able to get out of the arbitration. But the courts are kind of all over the map on that. So you need to be aware of those issues.
So if working as a subcontractor, if the contractor has a paid clause and they do go bankrupt or it does happen, is there something we can do, like put in our quote that if the paid clause is used, that it's not used through bankruptcy or something like that?
Well, you could, I'm not going to give you legal advice, I'm not your lawyer, but one of the things that you could do is you can maybe say that the paid clause cannot be used as a defense by the surety. You know, or the surety, the contractor hereby acknowledges that the surety is waived and the right to raise and pay. Bankruptcy is a whole different animal because you would go in and file a proof of claim in the bankruptcy court. And I'm lucky because I have a bankruptcy lawyer at my firm. And you would be shocked at how much bankruptcy and construction collides. We're kind of unusual, I think, at my firm because we handle a lot of surety and a lot of construction. And surety is a very complicated area of the law. And Steve Burprice, one of my partners, and he's been doing it for like 40 years. And I'm kind of, I work side by side with him. So we do a lot of surety and a lot of construction, and they really are a good mix, but you don't see that combination a lot. And then we do bankruptcy. But bankruptcy, the paid defense may or may not be effective in bankruptcy. You've got a proof of claim.
The contractor probably got paid.
Well, you know what I
If they
found
got
about
paid, they don't bankrupt.
You know what I found about bankrupt contractors for the most part is they have drained the bank account, mom's bank account, the dog, they sold the dog, the cat, the house, the kids' college fund. I mean, most contractors are not out, living the high life. And then, at least that's been my personal experience. I've been doing this for like 25 years. You've got some bad apples, but for the most part, they have tried everything to keep the business afloat because there's so much pride in our business, right? Most people in this business have a lot of pride in their work. You guys are entrepreneurs because you're insane to be in construction, so you have to be an entrepreneur because it's a very high-risk business. So that's why I'm here to help you understand the risks associated with signing contracts and associated with estimating, which ultimately forms the basis of the contract. The other thing that I would strongly recommend you do, if you can, is that when you submit a bid, that you reserve the right to review the contract. You don't want to submit a bid, get a job, you're all happy, and then somebody slaps a contract in front of you that's just got these terms that's, had I known this, I would have included some of this in my numbers. It's that jerk factor again. So those are some other things to think about. I talk in here about different types of contracts. You guys know all about that. I'm not going to go through all that. One of the things that we should talk about, does anybody have any questions or comments?
Can I have one of those?
Yeah.
Can I have one of those, please?
Yeah, absolutely. Anybody else need one? Sorry.
No worries. I came in late.
So the other thing we ought to talk about is the timing of payment. So is everybody familiar with the Prompt Payment Acts in Kansas and Missouri? If not, you should be familiar with them. I cite them in the materials, but you really need to be familiar with the timing of payment and then, how much retainage can be held. There are a lot of people that have this misperception about retainage and what's required and what's not. The statutes in Kansas are pretty specific on that. We talk about the 10%. It can be reduced to 5%. It doesn't have to be. There's also, when I say timing of payment, there's really 3 ways to get paid. One is, let's see what page is this on. There's 3 types of clauses. Oh, I guess these are not numbered, I'm sorry. It's in paragraph 7, it talks about shifting of the risk of non-payment. So we have paid when paid clauses, paid if paid, and payment by a certain date. I had a conference call the other day, and one of my clients said, well, there's paid and paid clause in the subcontract. I said, great. I don't have a copy of that. Can you read it to me? He's like, yeah, I'll go get it. Because we're trying to talk about, how we're going to handle some of the claims that are coming in. So he reads it. It says, so payment to, well, actually it's a contractor. And he says, payment to the subcontractor will be made when the contractor receives payment by the owner, and if it does too. And I was like, okay, is there anything more? And he's like, no. I said, who wrote that? If that was a lawyer, you need to tell them to put their malpractice carrier on notice. That's not a pay-to-pay clause. I don't know what that clause is. But a paid when paid clause is basically a timing mechanism. So the contractor would say, for example, when I get paid by the owner, I'll pay you within 60 days. Or when I get paid by the owner, I'll pay you in 30 days. Things like that. There's always kind of a timing mechanism in that sentence or that paragraph. And under a paid when paid clause, ultimately, if you do not get paid, if you're the guy trying to raise the paid when paid clause as a defense, ultimately you will have the duty and obligation to pay the downstream sub or supplier or subcontractor. Okay? Because that helps to delay payment, but what courts have decided is it's a reasonable time period. So they may not hold you to the 60 days. Let's say it says, I'll pay you when I get paid, but no later than 60 days after, I get paid, or no later than 60 days after you get your payout, or whatever, any kind of timing mechanism. Let's say you go 90 days, 120 days, you get beyond the 60 days because you've never been paid by the owner. The courts will eventually make you pay, and they look at the reasonableness of the timing. What are your efforts in trying to get paid by the contractor? What kind of demands have you made, things like that. So that is not a paid, if paid clause. Ultimately, you are legally on the hook. Now, paid if paid clause, different jurisdictions have determined what is a paid if paid clause and what is not. Some jurisdictions have held them to be against public policy, and so you can't necessarily have a paid if paid clause in every state. But for the most part, most states have adopted or upheld and allowed paid if paid clauses to be used. And I was trying to see if I quoted any language in here. I don't have any specific. If you have any questions, you can call me about whether your clause is a paid and paid. But basically it says that the subcontractor will be paid regardless of whether the general is paid by the owner. So it's got to be contingency language. For example, let's see. I think I said that backwards, actually. Yeah, I'm sorry. Hold on. On a paid clause, ultimately what it says is that the contractor will pay the sub if the contractor is paid by the owner, and that the contractor will only pay the sub if the contractor is paid by the owner, and that the contractor's receipt of payment by the owner is a condition precedent or precedent to the contractor's payment to the sub. So that's a key language, is the condition precedent. Some states have said that you have to take the next step and say, and the subcontractor assumes the risk of non-payment. Like Colorado, for example, I'm licensed in Colorado, Missouri, Kansas, so I'm constantly trying to figure out which state I'm in. But in Colorado, the courts make you take the next step and specifically put in language about that assumption of the risk. But for the most part, as long as the clause just says, I, the contractor, will not have to pay you sub unless and until I'm paid by the owner, and my payment to you is conditioned upon my receipt of payment, that's going to be satisfactory in those courts. They just want to know that the sub has been placed on notice, or your sub-sub has been placed on notice, that if you're not paid, you're not the bank, and I'm not guaranteeing payment. And those clauses are routinely upheld, so you need to be aware of that.
Does that work in Kansas?
Yeah. Yeah. Now, paid clause is not going to be a defense to a mechanic's lien. There's statutes that say that in Kansas.
So you can't place a
You
mechanics
can
lien.
still place.
You can place a
Yeah,
mechanic's lien.
even if that was.
Yeah. Hey, the other thing I want to tell you right now while I'm thinking about it is, I want you to, if there's only two things you remember when you walk out of here, I want you to remember this. Number one, you cannot toll a statute of limitations on a lien. I don't care what anybody tells you. What I mean is, if you have lien rights, you have to file your lien within the statutory time period. You cannot reach an agreement with another party that you can toll or stay or freeze, however you understand, take a snapshot in time and we'll revisit it later. That's not going to work, okay? The second thing is, on a bond claim, I get attorneys that call me all the time about this. The same answer is true, particularly under the Miller Act, when you have a federal bond involved. You cannot toll the statute of limitations. So look at your bond, look at the local statutes. The other thing I see a lot in Kansas is AIA bonds are issued and the statutory bond is issued, and clients call me all the time, which bond controls, I don't know what to do. I mean, both surety clients and contractors, and I've researched this, and there's really not much case law out there, and what I've concluded is the more restrictive will apply. So if the bond has a 90-day provision, for example, if it's an AIA bond, you're only going to have 90 days if you do not have a direct contract with the contractor to get a bond claim in. So go with the more restrictive, whereas in Kansas, I think it gives you, 6 months or something. Just follow the more restrictive. The likely thing is that the courts will give you more time as a claimant. They're probably going to give you more time, but I think an easy rule of thumb, rather than trying to kill yourself over, do I follow the 90 days or the 6 months, is follow the shorter time period. And you cannot extend those deadlines. I mean, if they're hard and fast deadlines in a bond, just like a lien, follow what the bond says, because it is a contract, and you're not going to get around it ultimately at the end of the day. Let me answer his question first.
So if there's a pay when paid only that stipulates the time you're paying, what actually obligates them to pay if they haven't paid? Is it statute or?
No, it's just case law says courts have determined that buys you time to go out and try to collect the money ultimately from the owner or the contractor. But ultimately, it's not a fee shifting provision. It doesn't, or, an interest, or, I guess a fee shifting provision. It doesn't ultimately shift the risk of the money of the to the subcontractor to bear the risk of non-payment, that you essentially entered into this contract. There was a meeting of the minds. You told them how much you were going to pay them, and you didn't state anywhere in the contract that it was contingent upon some other action. It's just like any other contingency clause. You can have a contract that says, I will pay you $5, but it's contingent upon you, buying red paint, painting this wall red, and then, putting a fence up, right? That's a contingency. That's no different than saying, I'll pay you, but it's contingent upon you getting it from the owner. Does that make sense?
Yes.
Okay.
Private project, as a subcontractor, how do we find out who actually has the bond project, or if we do have a bond?
That's
If
so
you're a
challenging.
developer can have a bond, the builder can have a bond.
I write everybody. So the first question I ask my clients when they call me is, they're like, I want to file my case. Like, that's great. What about a bond? Because, and they all say, well, it's a private job. There's no bonds. That's not true.
If there's financing with a bond typically.
No, that's not. You would not have a right to make a claim on a financing.
No, but typically if somebody finances a building to be built, like a commercial building, the bank would require that.
I would not agree with that statement. I am shocked at how many banks, because I represent developers,
Right.
advise my clients they don't need a bond. It's ridiculous. And you know why? They don't care, because they have a priority. Because they're going to make the contractor sign a document anyway that subordinates to the bank's rights. So they don't care. So if you're a developer in this room, you need to be getting bonds. If you're a contractor, it's the greatest thing in the world, because the banks are, I don't know what the deal is, but it's terrible advice. Now, if you're a subcontractor and you're trying to get the bond, what I do is I tell them, write the contractor, send it by certified mail, return receipt requested, write the owner, or you can copy the owner on the letter, return receipt requested, and you might copy the lender. I think that's a really good idea. They may not respond. You write the second letter. Ultimately, if they don't respond, you have to sue to get the bond, because you can always argue to the judge, well, they didn't give it to me, whatever. That's, I don't know how a judge is going to come out on that. The judge might say, well, gee, why didn't you just sue for it? So my advice is you write letters, you send them out certified mail, you make every effort in the world, be aware of the statutes and what the time parameters are, even for private projects. In some states, there's statutes on how long you can make a bond claim, and then you sue if you don't get it.
How do we find out if a job's going to have a bond? Is there a way to know?
Yeah, you could ask that question. But that's true. That's a good idea, as you'd ask up front.
Estimator may not know the president of the corporation.
That's right.
He says, I don't mind you working with an estimate if you're not the president.
Yeah.
Speaking as a general contractor, usually in the project specifications, if it's drawn up by an architect in the front ends, in the Division 0 or Division 1, there will be provisions in there or
I see a lot of that on school projects.
Like bonding is required.
Yeah. if the speaking also as a general contractor, if we are required to do a PCD bond, we will request that of you as well, most of the time. I don't know. if
Yeah,
many
that's a
general
hit or miss. I mean, some of them ask for LOCs, letter of credits.
Yeah, it depends, it depends. I know if we do it as for a public project, then yes, we will do that. Most of the time with private projects, we try to go to CDI or subguard avenue versus a bond, just because it saves money on other ways.
The other thing that a lot of my clients, general contractors, do is if it's a contract under a certain amount, they won't ask for bonding. If
Yes.
it's a contract over, so like some of them are at 25,000, some of them are at 100. It depends on, some of them will break the contracts up into two.
Yeah.
You know, I mean, there's a lot of,
Yeah, and it depends on
I think that's how I
financing,
operate
it
it.
depends on our insurance, what our insurance
Yeah.
dictates towards us.
Right.
I know we have a big pre-qualification process that a lot of contractors have to go through us, because that's the stipulation of our insurance.
Well, which is probably
General
good
market.
practice.
Yeah.
And for the subs that work really hard to do good business and stay out of trouble, that's great for them too. And you know what's the other thing that's, I mean, we're getting a little off track, but what I think is shocking, like I live in Lawrence, Kansas, and they're building a facility and they, you know, are sending it out for bid and they're having these contractors fill out questionnaires, but it's like they never have a lawyer review the questions because it's things like, well, how many lawsuits have we been in? Well, most of us don't litigate anymore, right? We arbitrate. So they don't think about, you know, how many cases have been filed against these people, how many times have they arbitrated. I can name one contractor for sure in town that would probably say they've only been involved in maybe 5 lawsuits, but I know for a fact, because one of my partners does a ton of arbitrations and I've arbitrated against them many times, they've probably been in like 100 arbitrations and litigation. I mean, that's a vastly different perspective, you know? So when you're a contractor, if you're vetting, you might ask just also like lawsuits filed against you and arbitration, but anyway.
Who sets the window for the time period that somebody can claim? You said 6 months and you said 90 days.
Well, so the AIA 312 is a form that's commonly used in the industry, and the AIA, if it's not been modified, says if somebody has a direct contract with a contractor, they don't have to jump through a bunch of bells and whistles, they just sue within a year. But if they're a subcontract, a second-tiered sub, they have to do certain things, and they have only 90 days from the date of their last court to give this very specific notice.
And then the bond company would be bound to the AIA.
Absolutely.
Correct.
Yeah, because they're the ones that issued it, yeah. And then, but in Kansas, if you do a 60-111 bond, which is a statutory bond, in some ways, it can be less restrictive because it has less restrictive terms in it, so you just kind of have to sit down and reconcile the two. Does that make sense?
Okay, the statutory bond, performance bond.
Well, okay, so that's kind of an interesting point. No, yeah, exactly. Think of it more like that. You got a payment bond and you've got a performance bond. That's right. That's right. And well, no, you would have a payment
I
bond.
would have a payment bond.
Correct. You would have both. They usually go hand in hand, payment bonds and performance bonds. They can be on a form, which is an AIA form, which is not statutory, that's a privately, typically a private bond, although I guess some municipalities adopt that form because I've got a case right now. Then there's statutes that basically describe like what should be in the payment bond. Statutes don't typically address performance bonds. And then you've got, I just saw an AGC payment bond last week for the, I mean, I've been doing this a long time and I've not seen one of those very similar to the AIA bond, where somebody took the AIA bond and put it on an AGC letterhead because it's almost exactly the same. The other thing that I'll tell you, I mean, it's just these little details that I want to point out. Like my client in this case said, well, there's no requirement for the sub, there's no timing mechanism for the sub to make a claim under this bond. And like, I read it within 2 seconds, and I said, well, yeah, it says 1 year. And they're like, no, it doesn't, no, it doesn't. They were looking for the number 1. It was written out as 1, and it was buried, which is understandable, but it was buried in the middle of his bond, so you have to slow down and read every word of these documents, because they're all contracts, guys and gals. They're all contracts. They all have legal meaning. I have another case. I mean, this is just the little things I want the estimators to pick up on. Is I have another case where the understanding of the contractor was they were going to work on 2 floors in a building, okay? But to access one of the floors, they had to come up through a floor underneath, understandably, to access plumbing and stuff. So the floor underneath was part of an alternate was to demolish. Let's say it's floors 1, 2, and 3. Okay, the contractor entered into contract for floors 2 and 3. They're going to go in and demolish it and rehab or remodels floor 2 and 3. They have to get into 1 to access floor 2. Okay, there was an alternate to demolish floor 1, and the owner didn't pick that alternate. Okay, so the estimator, when the contract came out, the estimator put in the contract that there was an addendum, and he wanted to be more specific, which I thought was really good. He wanted to be very specific on some details because alternates had not been accepted. And quite frankly, had he just not done this one thing, I think I would have a better argument in this case. But what the estimator did was said, the floor 1 in our hypothetical is going to be free from obstruction. Does free from obstruction, is that the same thing as demolished?
No.
It's not. It's the little words that really have a lot of meaning, guys and gals. And had he said it would be demolished, or we have no, that it's going to be open and there's not going to be any ceilings, and we're going to be able to access all of this equipment, it's free of obstruction, and all the furniture will be removed. So, now we're going to be litigating for 3 years over the meaning of words. So I just want you all to think about, if you have an alternate or you have a situation that comes up, one thing that we were taught in law school is do not reinvent the wheel. If the case says, obstructions are allowed under the contract, or, you will be paid for any obstructions, then use that word when you're saying obstructions are excluded, and if we have to deal with obstructions, we will be paid. If the word is demolished, use the word demolished. Don't use your own word, because your word has a different meaning than the word in the contract documents. Okay? Or if you don't understand the word, look it up, but don't change it. Okay? So, oh, come on now. If you can't read, I cannot help you. We talked about no damages for delay clause. I hope you guys understand that. That means that you don't get money, you just get time. That can be very problematic. I mean, I change those clauses when I review my clients' contracts, whether they're a contractor or a sub, because I just think if the contractor is at fault for the delays, the contractor should pay for it. It's not fair to have a contractor that's out there, not directing traffic in the way that they should, and have the subs pay for it. On the other hand, the subs have to be reasonable, because construction is not a perfect science, and things happen. So you guys have to work together as a team, or you're going to be hiring a lawyer. And again, the profit margins are not that great, so you really do not want to be, have a lawyer on hand at all times, or you're not going to make any money in this business. We kind of touched on the Kansas and Missouri variance Fairness in Private and Public Construction Acts, but basically those are prompt payment acts. So those acts do kick in and talk about payment and the timing of payment. And there's some pretty harsh penalties if you don't pay within those time frames. The pay-to-pay clause can still be raised as a defense. But the game of, well, you gave me a pay app and I didn't approve it, so you can't get, 18% interest is not, that dog's not going to hunt. Now, there's not a lot of case law about this, but the few courts that have opined about the prompt payment acts have said there has to be an element of reasonableness. Remember we talked about good faith and fair dealing? So if a sub gives a contractor a payment application, or a supplier gives a subcontractor a payment application and it reasonably should have been approved, then the clock will start ticking. On the other hand, if the contractor has reasonable defenses to your payment application, it's likely that you're not going to get that prompt payment interest and attorney's fees. That's a subjective determination. The courts have a lot of discretionary ability to make that decision. So, any questions about that? No. Okay, we talked about payment clauses. Okay, terminations for cause and terminations for convenience. That's in the paper. Those are contract clauses that you want to consider. What I always ask my clients to do when I'm reviewing those is, if you're terminated for convenience, because either financing, stopped, or, by the way, on a termination for convenience clause, you can get terminated for any reason. I mean, the contractor just decides they don't like you. That's okay. That they're allowed to do that. But what you need to think about is if you do get terminated, what do you need to kind of make it fair to you? Because you got to demobilize from the job, you might have materials that are out there that you paid for. There might be specialty order materials that haven't been delivered yet. So you really need to think through, and the same is true for contractors, you really need to think through the termination for convenience. It's more important, I think, for a contractor to really put some thought into that, because you have a lot more parts and pieces. You may have trailers, personnel, things like that on the job site that the subs don't have to deal with. But you need to think those clauses through and think about what it is you want. Now, thinking that you're going to get your lost profit is not going to happen. I mean, that's just not reality. I've probably negotiated a couple of contracts where I've gotten some lost profit in special situations because the owner really wanted my client and it was a good relationship. But that's very rare. Usually it's like, what's it going to take you to get off the job, stop your contracts, cancel them, think about restocking fees, okay? All kinds of things that you need to be thinking about.
Does that go both ways, from a subcontractor to a general standpoint? If they're 60 days late, the entire project, can a subcontractor terminate his contract with general?
Typically, that's not how they're worded. Now, there are, I typically do add in a clause for my clients, for both generals and subs, that say if the project's at a standstill for 90 days or more, I don't think 60 is reasonable, but 90, then I try to get my clients, give them the option to walk away from the project. Because, if there's a dispute between the developer and the lender over financing, I mean, you can't just sit out on a job forever. And also, if that dispute does not end well, you're out there now at risk, right, with trailers and people and personnel. I mean, even if you're able to kind of pull off and go to a different job, you're still losing money every day that you're out there. I don't care how well you mitigate your damages, that's just the reality. So you want to try to, especially if you're a contractor, you really want to have that out so that if you're more than 90 days out, you have the ability to leave, and then once they call you back, you have the option of not coming back, and if you do come back, they have to pay you this and this and this. I routinely negotiate those, and that's a great question. But typically from a sub to a contractor, it's just a one-way street, because the contractor needs the flexibility that if the owner comes to them and says, you know, I want you and your ass and everybody else off the job, they have to, I mean, it's a reasonable clause for them to ask for, because they have to be able to terminate you, and then they will flow upstream to the owner, whatever it is that you negotiate with them in terms of what you need to get off the job smoothly and effectively. But I also think that you need to consider as a sub, you know, this 90-day thing too, because you're just like the contractor, you can't be at their beck and call. I mean, if for some reason they get a dispute with the owner.
Supervision out there and their job is a mess and you're not making any money, you would think.
That's different. You're not gonna ever I don't think that any contractor will ever agree that if your project's a mess and you're not properly supervising, then I can walk off, because that's a very subjective question. I mean, what you think is a mess on a job site might be different than what he thinks is a mess on a job site. What you think is competent may be different than what he thinks is competent. That's very subjective. But somebody giving you a stop work order and you're down 90 days, that's very objective. I mean, that's an easy way to measure a point in time or some issue. Does that make sense? Huh?
It doesn't seem very fair. They can keep you off, they don't like it.
It doesn't seem fair. The best advice I can give you is document, 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 document. Take photographs, write letters, write emails, and document. Because let me tell you something, the written evidence in any case, I don't care what kind of case it is probably going to prevail. I mean, any good judge, any good lawyer, the first thing a judge is going to ask, and the first thing I ask my clients is, that's a great story. Where's all the documents and photographs? Oh, I never documented that. And then the other side's like, that is a bunch of lie. Here's a self-serving email that I put together that your client never responded to. It makes our job very difficult. So document, document, document. The other thing you need to be aware of is a lot of contracts now are requiring you as the subcontractor or you as the contractor to continue to work even in the face of a dispute between the parties. And it'll say, you have to continue to work even if it's a payment dispute, and the owner has to continue to pay you in the event that there's not, anything that's not a dispute. That can become very burdensome on a contractor, particularly if the dispute is about large change orders, very large. I mean, like on the case that I had involving Balfour Beatty over Fort Riley, you're talking about $93 million in disputes, and I had $45 million in subcontractors that had sued my client. So I was trying to fend off $45 million in claims while financing the completion of a project, which cost my client millions, while losing, out on $93 million. Now, I had a client that could sustain all that because they're a multi-billion-dollar company, but that's not every contractor, and that can be very difficult. And I know, that's what happened on the West Edge is that, J.D. Jones kept going and doing it, and then they would arbitrate little issues, and it gets very difficult. Yeah.
Okay, as a contractor, once I see a stop work order, I'm pretty much done as a sub. Because once it's not financed or something like that happens, there's a big problem. The guy that's not going to get paid is the guy that's actually doing the work. So once the stop work order comes for me, we remove what we do, whatever it takes with whatever we return material, whatever like that. Even if they have a provision in a contract that says that I have to keep working, if they've stopped me from working, to stop my ability to earn on that project, what would be wrong with me legally walking away?
Okay, well, there's two issues
They're
there.
going to sue me back. I might lose my retainage, but at least I'm not going to go bankrupt.
Well, there's two issues. What I hear you saying is two issues. If you get a stop work order, you have to stop.
No problem. No big problem.
Okay, so you stop, you mitigate your damages. What I think he was talking about is, do I have to keep working under circumstances where the contractor is not properly scheduling the work, I'm operating at a loss, it's becoming unburdensome, and the best thing I can I advise every client, any client that I have, and they don't always like it, But I think it's the best advice, finish the job. If you can finish the job, because I'll guarantee you, if you don't finish the job, the owner's gonna say, well, you screwed that all up, and I have to pay $10 million to tear out that $100 wall. Because, you know, it affected the river, you know, I mean, it's just ridiculous what they will come up with. So if you can afford to finish the job, finish the job. Document, 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 document. Because if you finish the job, you are in control of your own destiny.
They cause us to stop. What means we have to start?
I don't know, I haven't read your contract. But
Well,
if you
I'm
have a
just saying, you know what I
stop,
mean?
but if you have a stop work order, you probably need to stop,
Yeah, we're gonna
pull up the
stop.
job, and do whatever it tells you
We
to
have to come
do.
back. That's, you want to work on something that's already been stopped like that, typically, once it's been stopped, it's
Well, that's not always the case, like on some projects that I've litigated, we had a big dispute about the stop work orders that were issued, and my client was a general contractor in that case. It was like we stopped the work because a safety issue came up, and then there became this big dispute about, you know, why there was a welding issue and all this stuff, and it's like, and then, so then at that time, the subcontractor alleged that because of the stop work order, they suffered all this damage, and it's like, no, you didn't. Just pull your ass off the dock, go somewhere else, do whatever you can do, and then come back. There is going to be some cost for demobilizing, but most subs are so busy right now, you're probably like glad to be stopped on the job so you can go, you know, pile up on this other job and catch up on that job. I mean, that's kind of the nature of the beast, is sometimes you have to stop, there's issues that arise, but you're right, ultimately, if it's starting to smell like this is just me working and working and working and I'm never gonna get paid, I think you have the right to demand mediation right then and there, and I've done that before in the middle of a project. Demand assurances from the contractor that you're gonna get paid, that'll flush out the issues. You know, ask them, if they're not comfortable paying you, ask them to put the money in trust, put it in your attorney's trust account. I mean, there's a lot of ways that we as attorneys and you guys can think outside the box in trying to resolve these matters. I mean, it does not have to be, you know, square pegs, square holes. There's creative ways of getting through it, but you have to be open to these ideas because they're not always, you know, right. Yeah.
If it says you have to keep working in our contract, but then on the other hand, there's a duty of care business that says you have to stop costs, right? You have to stop the loss.
Oh, the mitigation.
The mitigation.
Yeah.
So if they're stopping your work, and it says you're supposed to work, and you know there's problems, isn't the duty of care of not working going to be more important than you? We're going to sit there and say, hey, and I knew they were going to bankrupt, and told me that they were going to have to keep working no matter what. They're going to say, sorry.
Yeah, I mean, these are, you know, these are issues that come up.
Safety issue, it's normally not a safety issue, stuff.
Yeah.
It'll close it down for a day.
Well, you know, you just have to use your common sense, gather all the facts, put together emails, and I suppose if you really think, you know, I mean, it also depends if it's liquidated damages, because sometimes it's better to pay the LOEs. I mean, there's just a lot of factors that you have to consider. Anybody else?
Just tell them you're gonna walk. That usually solves the problem.
Yeah, if you write a nasty gram, a lot of times that does solve the problem.
Tell them
Yeah.
you're gonna pull off.
I mean, you can always file a lien, you can do it prematurely, you don't have to wait. I mean, there's a lot of things that you as a contractor or a subcontractor can do to get an owner's attention. And most owners, I mean, in my experience from representing them and litigating against them, there's a few exceptions, but most owners just want to finish their job and get their renters in or get the business going. They're business people, they're bean counters, they don't have the stomach for litigation like we do. I mean, most of them, they're going to play hardball with you, but at the end of the day, they want the building, they want it done, and they want to get the renters in because they want to start making money, especially if there's like an AIA contract where there's a mutual waiver of consequential damages and the owner's not going to get lost rents. I mean, that's a really good, you know, argument that you have. I used that recently to settle a very difficult case. It's like, well, we can sit around and argue about this for 2 years and you're not going to have any renters in there. And by the way, you don't get consequential damages. But we could get this resolved today. You might have to pay a little bit more. And that brought a lot of clarity to the issues. So, are you here for me or?
No.
Okay, all right. Yeah, go ahead.
Does termination, what does it do to warranty? Or installed?
For termination, what does that do to warranty? Well, I mean, if I'm representing, let's say, a roofing subcontractor is a good example, I would be writing a letter saying, you're terminating us from the job, the warranty is hereby void. I mean, for example, GAF, okay, they're a common roofing, company. I mean, ultimately, if the job gets built and GAF comes out and it's an all-in warranty and they warrant it, I mean, they're gonna warrant it. There's not a whole lot you can do to stop that. There are some things. I mean, ultimately, you would want to write a letter disclaiming any warranties, but you don't necessarily want to work. I see some subs that work counter to that. And I think at the end of the day, if the owner gets the warranty from GAF, for example, that's just one less argument that you have to contend with, right? Because if you're constantly trying to make it difficult, and I'm a pretty aggressive lawyer, don't get me wrong, I'm not gonna roll over, but I'm kind of pragmatic too. I mean, at the end of the day, if you give the owner what they ultimately want, a lot of times these arguments about the damages and everything else just don't seem to have as much need to them. I mean, it's like you got what you paid for. What are you bitching about, It was a month late. Okay, so we're going to litigate over, a month. I know it was a nightmare, but you got your building. You're still within your, your budget or whatever. So I'm just saying you can keep control over your work. Keep control over your project. It's your project. See it to the end. You'll have a lot more pride. You'll have a lot better control over the cost. You'll make sure that the owner isn't just dumping a bunch of wish list stuff on you and you're fighting about that. You're not having to hire experts, lawyers, etc. That's the end game, is to get the building built. But if there's major hiccups along the way, call your lawyer and get advice along the way. Don't just try to do it on your own. And document. I mean, estimators can document just like the project managers can, or estimators can be very involved in helping as the plans are revised, to stay in the loop. I had a huge case involving Fort Riley. I do a lot of federal litigation, I guess. I didn't realize that, but I had a big case involving Fort Riley project where, and this is typical on federal jobs, where they'll come out with 65% plans and then you bid it, but within the specifications, they'll refer you to other prototype designs of facilities all over the country. And so you're supposed to go figure out this design of this building in Georgia because it's going to be the prototype for Fort Riley. And somehow you're supposed to know all this. And you're supposed to review that, and that's supposed to be in your bid. And then they'll come out with 75% plans. And my client just was getting these plans and not increasing his price. And then, at the end of the job, he dumps a $500,000 change order on the general contractor. And when the general doesn't pay, surprise, the sub calls me. He's like, this is ridiculous. These plans were 65, and we were supposed to read this prototype design. And then they went to come out. I'm like, okay, well, as you were estimating and you saw the changes in the design, did you communicate that to anyone? Well, no, but I mean, everybody knew the design. No, you can't do that. You have to, as an estimator, stay on top of the changes, stay on top of the ASIs, really scrutinize these things so that you can, it not only avoids litigation, but it also, in fairness to the contractor, places the contractor on notice because they have certain time frames to let their owner know that there's changes and extra money. And ultimately what the courts will look at is, did the owner have the opportunity to make an informed decision? I mean, you added 32 windows, Mr. Owner. Didn't you think it was going to cost more? Yeah, but I didn't think it was going to cost $400,000. Had somebody told me that, I might have only added 15 windows. That's a reasonable response. So try to think about those things as you're estimating. Stay informed on the job. Stay on top of the design and the plans. And the rest should fall in place. There was one payment provision that we didn't talk about. I want to go back to real quick. It's basically payment by a certain date. That's in my list, and we touched on it, but I just want to tie it together. That's really the prompt payment acts that we were talking about. So you have to be mindful of those, even if there's pay when pay clauses, you still need to look at statutes and try to take all that into consideration. Project change provisions, I touched on this. You know, one of the complaints I get a lot from clients is I'm out in the field, somebody's telling me they want me to make a change, they're telling me if I don't do it, the project's gonna be delayed, they're threatening me, you know, they're gonna walk off the job, whatever. You know, I don't know what the solution is, except I will tell you, document, document, document. I guess that's your third takeaway. Document, 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 because even if you're out in the field, and you're under pressure, and you're in a situation where you can't just pull a change order out of your back pocket, or timesheets, which you really should be doing, by the way, or something like that, at the very least, everybody carries one of these, okay? And if your owner does not allow you to have one of these, have him or her call me. Because this could be your best friend. Because while you're on the job, if this guy who's a contractor is telling you to put in that extra wall, and you're saying, I'm in Kansas and it's got to be in writing, and he's saying, this has got to go, it's holding up everything, it's, you know, there's predecessor work, blah, blah, blah. Then get this out and say, Dear John, today you told us to put in this wall. We cited to you the provisions in the contract that require a written change order. You told me that this was essentially an emergency type of situation because there is an exception in contracts for an emergency. And we're going to proceed with the work, but we expect to get paid as follows, not just get paid. You know, 10 cents a block. I mean, whatever it is. The point is, don't just do it and then just, like, it just vanishes and then you hope later they will get paid, or the owner of the company's like, well, you were out on the job site, you know, you put down extra hours, who's going to pay for that? You've got to document this stuff. I mean, if it's that important, then the general contractor will sign your change order. If it's that important, the owner will sign your change order. And you have the right, by the way, to say, I'm not going to do it. I mean, you know, liquidated damages be damned. If your contract says the only way you're supposed to do change orders is if you get a written change order before you do the work, then that is your ticket out. To say, I'm sorry, it's your contract, not mine. That's what it says. Yeah,
That's where it goes back to you should know who you're working for first.
that's right.
Because a lot of times we only do certain work with certain people, and we know that even if we know a handshake and a yeah, we know we're going to get paid. I mean, that's why you should know who you're working for.
That's right.
You shouldn't work for people that
Tell
have a
them
history, have a
Typically
history.
learn that after you get burned.
You should work with people where you have a history of not paying dues or not paying people or not paying.
Now, I will say, I mean, we have contractors in town that have gone out of business for not being good to subs, but we have some. I know of one who went out of business because they did everything by handshake. They wanted to please everybody. And I think that the change order process, while not all that practical at times, most times, it also forces the contractor to stop and think about, have I gone to the owner, have I gotten this approved by the owner or the architect? Because contractors shouldn't be putting themselves in the position either of not getting paid. I mean, they can't afford to finance a job any more than you can. I know there's this misperception that contractors are slaughtering these hogs, but that's just not always true. I mean, sometimes they're working on much smaller margins than you guys are. Trust me, I know this. I'm intimately familiar with a lot of businesses. I see the financials. You know, I don't just do construction. I mean, when we bring on clients at my firm, it's like we want to be involved in forming their companies, helping them with their finances, you know, helping them expand their businesses, personnel decisions, because you really can help guide a client or a company better if you have that knowledge and understanding in that relationship. Otherwise, it's just like a case-by-case basis, and you don't, you know, there's just not that synergy. So, yeah.
I have two specific instances. I'm a concrete contractor. I dig a structural column in the middle of downtown. building inspector shows up, fine, pass. The ground guy, the engineer's representative shows up, goes to test the soil, immediately water comes in the hole from nowhere. 100-degree day. We have to do what the engineer's representative tells us to do to dry the hole. But we're in a safety situation. We have to fill this hole. We have no shoring. There's no way to shore it.
OSHA.
Well, yeah, so we're tough. We're almost in a safety situation. We do what it takes to dry the hole out. We do it properly. The engineer tells me what to do. The engineer tells me that I'm required to do this, or the representative does. It's coming from the engineer. That was the hardest change we're ever across in my entire life. It's been 9 months. But isn't there a certain line of state of Kansas? That's an existing condition situation.
Unforeseen, that was an unforeseen condition.
So it's
Yeah, and your
unforeseen.
contract
It's a safety
should
thing.
address that,
And
yeah.
the engineer has told me.
You should be
to.
entitled to payments under that. It's an
Right.
unforeseen condition.
But if an engineer requires something beyond their design, the representative comes out and tells us to do it.
Document
We
it, do
will
it.
document it, but it has to be done immediately.
Well, it's an emergency
Well,
situation.
so you dig a trench, same basic.
Yeah,
thing.
that should be an
If
exception.
you wait a day, that trench came in and killed a person.
Yeah, I mean, you're not gonna stand there and text because it's a safety
So
situation.
probably it's not an email real quick. and so-
At some point, you're gonna go home, and when you do, you're gonna give a very detailed email of what happened that day. I mean, if it's a
But that's-
$200
that's-
change order,
Yeah.
you're probably not gonna spend that much time on it, okay? Think practical, guys. But if it's a $20,000 change order, take the time to put in a detailed email what happened, who was there. I'll tell you, I have a client who, when those kind of situations come up, I mean, she is awesome. She records everything. I mean, I'll say, what you got for me? Because it's just, she's just like, and then, and isn't it true, and they don't know this, and isn't it true you told, yeah, I told you, and we talked about 10 million, yeah, that's right, we did, and she'll be like, here you go, and I'll type it in the letter, and I'll be like, on this day, you said this, and I quote, I mean, it's kind of hard to get out of that. If it's that kind of situation, you might record it, that's legal, you can do that.
Uncontrollable situation, that needs to be.
What's that?
An uncontrollable situation in Kansas could be different than if everything has to be right.
Well, it's not
Well, I
uncontrollable.
wouldn't
If it's an
call it-
emergency situation, a life safety issue, that always takes precedence, okay? If it's an unforeseen condition, like nobody anticipated, the geotech, there's no reports indicating that water or sand or, expansive soils or whatever the issue is was there, that's unforeseen. You have to document it, take photographs, and then, submit the claim.
That would be a situation where you're not going to have a change before you have to.
That's
But
true.
it takes, and we're in Kansas, so how do I? I'm going to send an email, that executive for that corporation.
You have a really good lawyer who
I
knows
don't
how
know,
to
I mean,
do that. That's what you
$4,000
do.
change orders in the.
Yeah, I mean, you're right.
My guidelines, it doesn't really matter.
I mean, that's what you would say to a judge, you're on the stand and like, Your Honor, do I say, excuse me, can I run back to the trailer to get a change order? Or do I say, hey, there's a guy in the trench and I don't want him to die? I picked the guy in the trench that doesn't die. I think most judges would agree with that.
That's just that you're.
Yeah, I mean,
that's
there's
not-
always exceptions.
Health and safety.
Yeah, these are not hard and fast rules.
Completely uncontrollable. Well, the situation can get worse.
I'm not subscribing to your word uncontrollable. That's not a term. I mean, I'm not trying to be funny. I'm
No,
just
but I
saying,
think-
the buzzwords that courts look out for are health and safety, emergency, unforeseen condition. Those are words that have been litigated, but that word that you're using is not. Yeah, unforeseen.
How would you expect one of the water?
What's that?
How would you expect a 10-foot pool when you
Right,
learn to drive?
right. Any other questions on that? Those are good questions. Anybody else? Come on, guys. It's like a lawyer's
One quick-
here. I'm $300 an hour. It's free. Yeah.
So quick question, you said that one of the people that you work with records,
No, not who I work with. It's my client.
one of your clients,
Yeah.
correct? Does she have to have consent from that person to record
No.
on what they say? It's not against
It's
the law?
Kansas. I don't remember exactly. I practiced in 3 states, but the takeaway is, yes, you may record it. Whether or not you can introduce it into evidence is a different question. It's not a criminal act to record it. In the state of Missouri, as long as one person is aware, one person that's in the room is aware that the recording is on, then the recording can be used. In other words, You can't just walk in here, put a recorder on, walk out, not tell any of us, and then try to use it as an admission against interest. I could come in the room, set it down with you and me here, and you not knowing I have it on, and it can be used against you. In fact, we used, in the Walton arbitration that Steve and I did, we got like $5.6 million verdict against Walton. One of the things we did was our client had recorded some conversations which were very damning to Walton, where they were like, yeah, we're gonna screw these guys, and we're gonna screw them out all their money, and let me tell you, it took like the arbiters 5 minutes after that to find it in our favor, so it can be very powerful. I mean, there was some good lawyering involved, but let me tell you, it was the recordings. That was a 2-month arbitration. All right, you guys wanna go get a drink? Yeah.